This is the Sunday stream opening song because the other song is copyrighted. La 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 la. Oh look, here comes Dog Cat Fox.
Hi, Sky.
Good morning, everyone, and welcome to the Sunday stream, the stream I do on Sundays, because Sunday is the day to stream on Sundays. Hope you're all doing well on this beautiful Sunday morning. It's actually sunny on a Sunday morning, which is kind of nice. Yes, we're back once again, but this time for education. At least I hope so. But I'll get into that momentarily. Who's joining me this morning for this educational stream? Because I aim to educate. Rotten Corpse, good morning. Mike R. Keeverdam, good morning. And also at the top of the chat box, Keeverdam has helpfully provided us the links to the fundraisers for our friends Maddie, Lissa, Angry Illinoisian, and Moonshock. And if you have a couple of bucks to spare, please consider checking out those fundraisers and throwing them some support. If you can't donate, that's perfectly fine. But if you can, share those links out on social media. That would very much be appreciated. So thank you ahead of time for that. Nathaniel Taylor, good morning. Spoony the Rebel, who else is here? Mike R, did I already say Mike R? But Ryan R, it's all the R's. R, 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 R. Stoka, or Brett Ide, good morning. John Miller. Who else here? Spud Gun, Lurking Gopher, Somnamnul Nation, Brittany Holland, Froggy, Floggy, Bridget, Big Time, good morning. Robert Pincus, good morning. Derek LaRue, as always, thank you so much for your continued generosity and support. Hope you're having a good Sunday. Hope you find this interesting and informative. I hope so. Thank you so much again. Dina B, good morning. Who else is here? Seftus Wolf, Tall Person, good morning. And if I missed you, if you're lurking, if you're in the future, good morning. Oh, Ostsan, good morning. All right, so I'm going to walk us through this because I really do want to try to make this as educational as possible because something incredible happened this past Tuesday. For those of you that were here or for those of you that weren't, I did a marathon stream where I read several articles talking about the possible ramifications that the Supreme Court's decision on affirmative action, by abolishing affirmative action in colleges and universities, how that decision might affect corporate DEI programs, because the justification for affirmative action in colleges is practically identical to the argumentation and justification for DEI practices in private companies. But unlike private companies, affirmative action only provided protection to universities and colleges when using race as a factor for opportunities. Businesses do not enjoy that protection, or so I thought, at least according to one article out of dozens that I've read both recently and over the years, in which a legal defense of DEI was provided. So I'm going to walk through this step by step, and hopefully we'll learn something together. So the first part is we have to know what Title VII of the Civil Rights Act of 1964 says, because Title VII, for those of you that don't know, covers what employers can, and specifically more so, what they cannot use in assessing someone for job opportunities, both in recruitment, employment, promotion, and so on. So we're going to start off with Title VII of the Civil Rights Act of 1964. And this summary comes from the Justice Department, and links to all of the information I'll be going over in this stream are in the description. So refer to that if you'd like. So here we go. Title VII of the Civil Rights Act of 1964 makes it unlawful for an employer to discriminate against someone because of race, color, religion, sex, including pregnancy, childbirth, and related conditions, sexual orientation and gender identity, okay, national origin. All right, so those are the ones you cannot discriminate against. And conversely, I don't think you can discriminate in favor of either. I think that's also implied, but I'm not a lawyer, and I'm not a constitutional scholar, but I would hope that would also be the case. Thank you, Big Time. Can't wait to hear how my children can be denied jobs in the future. Exciting. Well, we'll see. This is the stuff that I'm curious about. So continuing on in Title VII, thank you again, Big Time. And also under Title VII, it is unlawful to discriminate in any aspect of employment including hiring and firing, compensation, assignment, or classification of workers, transfer, promotion, layoff, or recall, job advertisements and recruitment, testing, use of employer facilities, training and apprenticeship programs, retirement plans, leave and benefits, or other terms and conditions of employment. Now, for those of you that have been paying attention to DEI programs with me for the last 7 years or so, you might wonder, how the heck does DEI get around this? And this is the question that I have been asking for the better part of 7 years. Every time I've come across a DEI program that sets a quota, every time I've come across a DEI program that says we're going to work with particular vendors because the color of the people that own them are X, or we have a job training program for people who are within this demographic, that kind of thing, I keep asking myself, and I ask the world, I ask the ether, how is this legal? My layman's understanding of the Civil Rights Act, specifically Title VII, would say that that's all, at the very least, highly questionable in legality, right? I've also asked the question over and over again over the years, if there is some kind of legal get around or loophole or exception that makes DEI okay, I'd love to know what it is. And yet, after multiple promotional videos, multiple panel discussions, multiple diversity consultants, articles, and onward, I've never had anyone tell me how DEI, as generally practiced, doesn't contradict Title VII of the Civil Rights Act of 1964 and thus make any company who is declaring themselves a DEI aficionado suspect of violating federal law. Well, all of those questions may be answered today. And I'll get to that momentarily. First and foremost, thank you again, big time. Attorney General of Arizona and Governor of New York State both said they will ignore the Supreme Court decision on affirmative action. Are they race traitors? I don't know what they are, but I wish them legal luck, I suppose. I'm not quite sure how they're going to get around the intention of Title VI, because Title VI deals with race, discrimination, race, gender, and otherwise in institutions that accept federal funding, which is why Title VI applied to colleges and universities when it came down to affirmative action. But that's also a good point, because here's what happened on Tuesday. Thank you again, big time. On Tuesday, I read an article, and those of you who were there for it, you heard it in my voice. I was shocked and amazed, because apparently, according to two legal scholars in this article, there is a legal defense and a legal protection of DEI programs. So I've cut out the segment of that article, and again, the link to the original article is in the description, and I've pulled out the pertinent portion of it for the sake of reference. Okay, and again, from all I've ever read or heard or listened to about DEI, I have never heard, so far as I can recall, I've never heard any legal precedent, justification, law, exception ever quoted that says that what goes on with DEI isn't a violation of Title VII. But here we go. Catalyst, this comes from the Catalyst blog, by the way. Catalyst reached out to Kenji Yoshino, Chief Justice Earl Warren, Professor of Constitutional Law and Faculty Director of NYU's Law. I did it last time too. NYU Law's Meltzer Center for Diversity, Inclusion, and Belonging, and David Glasgow, Executive Director of the Meltzer Center, for their response to the decision, as in the decision against affirmative action, and their thoughts for U.S.-based companies. And skipping down in the article slightly, however, the decision will have little immediate impact on the legality of workplace DEI initiatives themselves for a few reasons. And here's the most important one. For starters, the court's decision was about affirmative action in higher education admissions, not affirmative action in private workplaces. Now, I've rarely, if ever, heard affirmative action being used as applicable to workplaces. It's always been used as a reference to higher education. So to read it here used in reference to workplaces is still odd to me. While the court held that affirmative action violates the Equal Protection Clause in the U.S. Constitution, and by extension, Title VI of the Civil Rights Act of 1964, it did not hold that affirmative action violates Title VII of the Civil Rights Act of 1964, the main statute governing the employment relationship. To end workplace affirmative action, the court would need to overrule two of its long-standing precedents, United Steelworkers v. Weber, 1979, and Johnson v. Transportation Agency, 1987, which authorized affirmative action under Title VII. Okay, so again, unless somewhere in the annals of all of my videos on this subject and elsewise, I have somehow missed it. As far as I can tell, this is the first time, this is the first publication that I've ever seen, quote, legal precedent to say that DEI has protection against Title VII. And remember, just in the weeks prior to reading this and leading up to the court's decision, I read articles from the Wall Street Journal and Bloomberg and the New York Times and countless others that I didn't necessarily go online with. And in none of them did they ever mention these cases as creating an affirmative action defense against Title VII for DEI practices. So this is bizarre to me, and I'd never heard of these cases before. And so, with all of that as preamble, I went, and I know it's not exactly heavy lifting these days, but I went and I found copies of these court decisions. And so for the first time, because I haven't read them yet, for the first time I'm going to read them here, as I have previously with the court's decisions on affirmative action and the school student debt decisions. And I'm going to use my layman's brain, my non-legal expert brain, to find out how these two cases, according to our experts, create an affirmative action defense for businesses and their DEI programs against the restrictions of Title VII. Now, again, I haven't read these before, so you'll be going through them at the same time I am. But before I begin, I have two questions going into this that I hope to have answered at some point in my lifetime. Number one, if these two cases effectively create an affirmative action precedent that allows DEI programs to operate in companies in defiance of Title VII, what is the point of Title VII? I mean, if these two cases basically void Title VII, then what is the point of Title VII? How do you ever enforce Title VII if there is this, again, purported affirmative action defense? And secondly, my second question is, if these two cases do create an affirmative action protection for businesses against Title VII, how quickly can we get rid of these as we did affirmative action in colleges? Because I tell you what, I had thought that with affirmative action being abolished, the last bastion of legalized, systemic, institutionalized racial discrimination in this country had finally been knocked down. But if our two legal experts are correct and these two cases create a business affirmative action, then we still have work to do as a country. And I'll just put that in the most high-minded terms possible. So here we go. This is Steelworkers v. Weber, or Weber, don't know which, 443 U.S. 193 from 1979. Here we go. Certiorari to the United States Court of Appeals for the Fifth Circuit, syllabus. In 1974, petitioners United Steelworkers of America, USWA, and Kaiser Aluminum Chemical Corporation, Kaiser, entered into a master collective bargaining agreement covering terms and conditions of employment at 15 Kaiser plants. The agreement included an affirmative action plan designed to eliminate conspicuous racial imbalances in Kaiser's then almost exclusively white craft workforces by reserving for Black employees 50% of the openings in-plant craft training programs until the percentage of Black craft workers in a plant is commensurate with the percentage of Blacks in the local labor force. Wow, okay. This litigation arose from the operation of the Affirmative Action Plan at one of Kaiser's plants where, prior to 1974, only 1.83% of the skilled craft workers were black, even though the local workforce was approximately 39% black. Okay, so this, just as a pause, so the intention was to make the workforce represent the community surrounding it. Aha, so proportional representation, as they would say today. Pursuant to the national agreement, Kaiser, rather than continuing its practice of hiring trained outsiders, established a training program to train its production workers to fill craft openings, selecting trainees on the basis of seniority, with the proviso that at least 50% of the trainees were to be black until the percentage of black skilled craft workers in the plant approximated the percentage of blacks in the local labor force. During the plant's first year of operation, 7 black and 6 white craft trainees were selected from the plant's production workforce, with the most senior black trainee having less seniority than several white production workers whose bids for admission were rejected. Thereafter, respondent Weber, one of those white production workers, instituted this class action in federal district court, alleging that because the Affirmative Action Program had resulted in junior black employees receiving training in preference to senior white employees, respondent and other similarly situated white employees had been discriminated against in violations of the provisions of 703A and D of Title VII of the Civil Rights Act of 1964 that make it unlawful to, quote, discriminate, because of race in hiring and in the selection of apprentices for training programs. The district court held that Affirmative Action Plan violated Title VII, entered judgment in favor of the plaintiff class, and granted injunctive relief. The Court of Appeals affirmed, holding that all employment preferences based on race, including those preferences incidental to bona fide affirmative action plans, violated Title VII's prohibition against racial discrimination in employment. Okay, that was the case leading up to the court's decision. So, a company decided to, effectively institute what would be now called a DEI program of trying to balance their workforce racial demographic percentages against the demographics of the outside world, and doing so artificially, even regardless of someone's tenure or merit, in order to meet those numbers. And the lower courts found that this was in violation of Title VII. Okay. So here we go. Held. Title VII's prohibition against racial discrimination does not condemn all private, voluntary, race-conscious affirmative action plans. Okay. Respondent Weber's reliance upon a literal construction of the statutory provisions and upon McDonald v. Santa Fe Trail Transportation Company, 427 U.S. 273, which held in a case not involving affirmative action that Title VII protects whites as well as blacks from certain forms of racial discrimination, is misplaced, since the Kaiser USWA plan is an affirmative action plan voluntarily adopted by private parties to eliminate traditional patterns of racial segregation. Wait a second. Okay, again, layman talking here. So, because the company's plan was a benevolent form of racial discrimination, Title VII doesn't apply? Am I interpreting that correctly? Let's see. Quote, a thing may be within the letter of the statute and yet not within the statute because not within its spirit nor within the intention of its makers, unquote. Holy Trinity Church v. United States. And thus the prohibition against racial discrimination in 703A and D must be read against the background of the legislative history of Title VII and the historical context from which the act arose. Boy, this sounds very familiar, doesn't it? It sounds like some familiar argumentation. B, examination of those sources makes clear that an interpretation of 703A and D, and when I say 703A and D, it's talking about Title VII, that forbids all race-conscious affirmative action would bring about an end completely at variance with the purpose of the statute and must be rejected, Congress's primary concern in enacting the prohibition against racial discrimination in Title VII was with the plight of the Negro in our economy, and the prohibition against racial discrimination in employment was primarily addressed to the problem of opening opportunities for Negroes in occupations which have been traditionally closed to them. In view of the legislative history, the very statutory words intended as a spur or catalyst to cause, quote, employers and unions to self-examine and to self-evaluate their employment practices and to endeavor to eliminate, as far as possible, the last vestiges of an unfortunate and ignominious page in this country's history, unquote. Abermale Paper Company v. Moody cannot be interpreted as an absolute prohibition against all private voluntary race-conscious affirmative action efforts to hasten the elimination of such vestiges. C. This conclusion is further reinforced by examination of the language and legislative history, which provides that nothing contained in Title VII, quote, shall be interpreted to require any employer to grant preferential treatment to any group because of the race of such group on account, boy, there's a lot of ellipses in here, on account of, quote, a de facto racial imbalance in the employer's workforce. Had Congress meant to prohibit all race-conscious affirmative action, it would have provided that Title VII would not require or permit racially preferential integration efforts. What? The legislative record shows that 703 was designed to prevent 703 from being interpreted in such a way as to lead to undue federal regulation of private businesses, and thus use of the word require rather than the phrase require or permit in 703 fortifies the conclusion that Congress did not intend to limit traditional business freedom to such a degree as to prohibit all voluntary race-conscious affirmative action. What? So wait. Even though Title VII says, thou shalt not discriminate on the basis of these things, it doesn't really say you can't discriminate on the basis of these things. Am I reading this correctly? Again, okay, hold on, I'll finish it. Number 2, it is not necessary in these cases to define the line of demarcation between permissible and impermissible affirmative action plans. It suffices to hold that the challenged Kaiser USWA plan falls on the permissible side of the line. The purposes of the plan mirror those of the statute, being designed to break down old patterns of racial segregation and hierarchy and being structured to open employment opportunities for Negroes in occupations which have been traditionally closed to them. At the same time, the plan does not unnecessarily trammel the interests of white employees, neither requiring the discharge of white workers and their replacement with new black hirees, nor creating an absolute bar to the advancement of white employees, since half of those trained in the program will be white. Moreover, the plan is a temporary measure not intended to maintain racial balance, but simply to eliminate a manifest racial imbalance. That is some of the most mental gymnastics, convoluted, Title VII doesn't matter. What? That's amazing. Thank you, John Miller. Let me look into my crystal ball. What? Okay, so by this decision, again, as I asked at the top, Title VII doesn't matter. If your intentions in being racially discriminatory are to help one demographic, okay. All right, so as long as you are discriminating on behalf of the correct type of person based on the historical foundation of the statute, then Title VII doesn't matter. Title VII didn't say, thou shalt not discriminate against people of color. It said, thou shalt not discriminate against anyone on the basis of their race. But now the Supreme Court in this decision from 1979 said, nah, that doesn't matter. As long as your intentions are historically pure, Title VII is irrelevant. Wow. And why hasn't this been cited? If this is true, if this is still valid, why hasn't this been cited to me at some point in the past? Okay, all right. Well, like I said, this is amazing to me. And I always said that if somebody could point out to me where it is legally justified for DEI programs to do what they do, I would completely, step back and say, all right, well, I've had my question answered. But now it just causes a lot more questions. Now, has this decision been overruled in some way or overwritten in the time since? I don't know. But we're going to move on. Let's see. Austin asks, what does the dissent of this case say? I don't have it in front of me. That's a good question. I just got the majority. Let me get through both of the majority opinions on these cases, and then I'll go back and I'll try to find the dissents. Because, that would be interesting to see. All right. Well, that was Steelworkers v. Weber, 1979. So that by itself, I will have to confess, barring it having been overwritten in some way since then, that does create an absolute pathway for any business in the United States to take that strategy and take that justification for their DEI programs and avoid Title VII restrictions or penalties. That's amazing to me. That is news to me. All right, let's move on to the second case that supposedly creates this affirmative action defense, and that is Johnson v. Transportation Agency. Let me zoom in on that a little bit. No, not that one. Sorry. Wrong tab. How about this tab? There we go. All right, let's read through this. Johnson v. Transportation Agency, 480 U.S. 616, 1987. Okay, let me get my water here because I'm going to be talking a lot. All right, certiorari to the United States Court of Appeals for the Ninth Circuit syllabus. In 1978, an affirmative action plan, now known as the plan, for hiring and promoting minorities and women was voluntarily adopted by a respondent, Santa Clara County Transportation Agency, or the agency. The plan provides, inter alia, that in making promotions to positions within a traditionally segregated job classification in which women have been significantly underrepresented, the agency is authorized to consider as one factor the sex of a qualified applicant. The plan is intended to achieve a statistically measurable yearly improvement in hiring and promoting minorities and women to job classifications where they are underrepresented. And the long-term goal is to attain a workforce whose composition reflects the proportion of minorities and women of the area labor force. Okay, so this is very similar to what was going on in Steelworkers v. Weber. The plan sets aside no specific number of positions for minorities or women, but requires that short-range goals be established and annually adjusted to serve as the most realistic guide for actual employment decisions. So wait a second. The plan sets aside no specific number of positions for minorities and women, but requires that short-range goals be established. Well, what's the difference between a short-range goal and a specific number of positions? What? Okay. When the agency announced a vacancy for the promotional position of road dispatcher, none of the 238 positions in the pertinent skilled craft worker job classification, which included the dispatcher position, was held by a woman. The qualified applicants for the position were interviewed, and the agency, pursuant to the plan, ultimately passed over petitioner, a male employee, and promoted a female, Diane Joyce, both of whom were rated as well qualified for the job. After receiving a right to sue letter from the Equal Employment Opportunity Commission, petitioner filed suit in federal district court, which held that the agency had violated Title VII of the Civil Rights Act of 1964. The court found that Joyce's sex was the determining factor in her selection and that the agency's plan was invalid under the criterion announced in Steelworkers v. Weber, the plan be temporary. The Court of Appeals reversed. Held, the agency appropriately took into account Joyce's sex as one factor in determining that she should be promoted. The agency's plan represents a moderate, flexible, case-by-case approach to effecting a gradual improvement in the representation of minorities and women. Oh, boy. In the agency's workforce and is fully consistent with Title VII. It's fully consistent with Title VII? Where? A, petitioner bears the burden of proving that the agency's plan violates Title VII. Okay, well, Title VII says you can't discriminate on the basis of race or gender in promotions and hiring, etc. And they discriminated on the basis of gender in hiring and promotion. It's pretty cut and dry. His burdens, yeah, he does have the burden, I guess, but it's pretty, what? Okay. Before I get to that, thank you, Mr. Tickle Trunk, so much for the happy, smiley, lovely dog cat fox. Oh, dog cat fox.
Wowie, wow, wow.
That is a ranting monkey dog cat fox. Thank you, Mr. Tickle Trunk. I'm boggled right now. Okay. Yes. Again, petitioner bears the burden of proving that the agency's plan violates Title VII. Once a plaintiff establishes a prima facie case that race or sex has been taken into account in an employer's employment decision, race or sex or country of origin or religion, there's a couple other things in there, but whatever, the burden shifts to the employer to articulate a non-discriminatory rationale for its decision, such as the existence of an affirmative action plan. Wait. Title VII says you can't discriminate on the basis of, in this case, gender, right? Okay. It's flat. There's not a lot of room to maneuver in the law. Thou shalt not discriminate on the basis of gender. It's up to the plaintiff, the petitioner, to prove that. Okay, well, it's on its face a violation. But now that the accusation's been made, the only defense that they have to come up with is like, oh, well, this is part of an affirmative action plan. But if your affirmative action plan is in direct contradiction to Title VII, that's not a defense. What? The burden shifts to the employer to articulate a non-discriminatory rationale for its decision. It's inherently discriminatory, such as the existence of an affirmative action plan. Just saying you have an affirmative action plan is a defense against discrimination or makes something non-discriminatory? What? The burden then shifts to the plaintiff to prove that the plan is invalid and that the employer's justification is pretextual. It was she was hired on the pretext of her gender in order to balance. Okay, now, obviously, I am not smart enough to be a Supreme Court Justice of the United States, but I'm having a hard time making sense of this logic here, just as I was in the last case. Okay, B, assessment of the legality of the agency's plan must be guided by the decision in Weber. I guess so. Must be? It's precedent, not law, but whatever. Okay. An employer seeking to justify the adoption of an affirmative action plan need not point to its own prior discriminatory practices, but need point only to a conspicuous imbalance in traditionally segregated job categories. So all I have to do to get around Title VII is to say, there's a disparity that I am attempting to correct. Is that it? Voluntary employer action can play a crucial role in furthering Title VII's purpose of eliminating the effects of discrimination in the workplace, and Title VII should not be read to thwart such efforts. Wait. So, Title VII doesn't apply if my discriminatory practices are benevolent ones. If I can somehow argue to the court that, oh no, my discriminatory practices are all for the greater good, then Title VII isn't an issue. I ask again, what is the point of Title VII then? C, the employment decision here was made pursuant to a plan promoted by concerns similar to those of the employer in Weber. Supra, consideration of the sex of applicants for skilled craft jobs was justified by the existence of a, quote, manifest imbalance, unquote, that reflected underrepresentation of women in, quote, traditionally segregated job categories, unquote. Okay, so again, a disparity equals an inequity as far as the court's concerned in this case, and therefore Title VII doesn't apply. Because Title VII only applies if you're not addressing an inequity. I'm confused. Where a job requires special training, the comparison for determining whether an imbalance exists should be between the employer's workforce and those in the area labor force who possess the relevant qualifications. If a plan failed to take distinctions and qualifications into account in providing guidance for actual employment decisions, it would improperly dictate mere blind hiring by the numbers. However, the agency's plan did not authorize such blind hiring, but expressly directed that numerous factors be taken into account in making employment decisions, including specifically the number of female applicants qualified for particular jobs. Are we hearing the same defense, by the way, as we did with affirmative action, that race was just one of many factors considered when giving somebody an opportunity? Yeah, no, this really does create affirmative action in the workplace. Why have I never had these quoted to me ever before? This is crazy. Big time. Let me get it up here if it'll come up. Thank you so much. You say you are against race politics, Scribe, yet you live in the country that discriminated against your parents and possibly against your future children. Thoughts, Scribe? Yet I live in a country that, well, I mean, I can live in a country whose policies I disagree with. I mean, unless, of course, I live in a country where doing so is going to, cost my life or something. But I guess those are my thoughts. My thoughts are, I want these policies to go away. I want this inherent contradiction to what our principles are supposed to be in this country to be done away with. Because what is the point of trying to do away with judging somebody on something other than their merits in job opportunities using a law that says that explicitly if it doesn't matter? Yet reading this stuff reads like someone in DEI wrote these decisions today, because the arguments about representation, the arguments about, oh, we have to address the historical context and on and on and on, making all these exceptions to make certain types of discrimination okay, as long as it's against or for the appropriate demographics. Okay, let me back up a little bit. If a plan failed to take distinctions and qualifications into account in providing guidance for actual employment decisions, it would improperly dictate mere blind hiring by the numbers. However, the agency's plan did not authorize such blind hiring, but expressly directed that numerous factors be taken into account in making employment decisions, including specifically the number of female applicants qualified for particular jobs. Thus, despite the fact that no precise short-term goal was yet in place for the skilled craft worker job category when Joyce was promoted, the agency's management had been clearly instructed that they were not to hire solely by reference to statistics. Okay, and this is the point that I've made any number of times. If you have a pipeline of decisions towards landing on a candidate for a job, and at every section of that pipeline, there's a filter, right? Like filter number 1 is years of experience. Filter number 2 is skills. Filter number 3 is, education, whatever. At whatever point in that pipeline you get to the filter that says, what is your gender or what is your race? That's where the whole thing falls apart. You don't dilute, in my opinion, the effect of discriminating against someone on the basis of something that has nothing to do with their merits or skills by simply adding more things around it and saying it's only one of many factors. Well, if it's one of many factors, it's the factor that makes it illegal and, as far as I'm concerned, immoral. But apparently, in this instance, it's fine. As long as it's not the only factor, as long as you can try to justify it through other things first, you can mix in the point at which, well, your gender is a point in your favor, or your gender is a point in your disfavor. This is the exact same defense of college-level affirmative action. This is exactly what we heard from all the advocates for affirmative action. So I must be wearing orthopedic shoes because I stand corrected. There has been, at least as far as these two decisions are concerned, and I'll keep going to finish off this one, but at least as far as the implication of the second one and what was said in the first one, there actually has been a total workaround of the law for DEI programs this entire time. And it's insane. Okay. The fact that only the long-term goal had been established for the job category posed no danger that personnel decisions would be made by reflexive adherence to a numerical standard. But look at all these exceptions they're making. Well, I mean, it was only a long-term goal. There wasn't a statistics, but we're also talking about representation. We're also talking about the proportion of people in the labor force. But it's not about adherence to a numerical standard. It's just about taking the statistics of the population and sort of trying to make the workforce resemble that through artificial means. What? D, the agency plan did not unnecessarily trammel male employees' rights or create an absolute bar to their advancement. Yes, it did. What? He can't. Well, I mean, these days, I suppose it is a big question mark, but at least in 1987, the man could not suddenly become a woman and qualify when the restriction was they were going to hire for women. The agency plan did not unnecessarily trammel the male employees' rights or create an absolute bar to their advancement. The plan sets aside no positions for women and expressly states that its goals should not be construed as quotas. Oh, well, if it said that its goals should not be construed as quotas, then they obviously aren't quotas because they said so. Also, the Democratic People's Republic of Korea is really all of those things because it says so. This is a Supreme Court decision. This is thinking individuals making this call. Are you kidding me? The plan sets aside no positions for women and expressly states that its goals should not be construed as quote-unquote quotas that must be met. Denial of the promotion to petitioner unsettled no legitimate, firmly rooted expectation on his part, since the agency director was authorized to select any of the 7 applicants deemed qualified for the job. Express assurance that a program is only temporary may be necessary if the program actually sets aside positions according to specific numbers. However, substantial evidence shows that the agency has sought to take a moderate, gradual approach to eliminating the imbalance. What is an imbalance if not a statistical analysis? Eliminating the imbalance in its workforce, one which establishes realistic guidance for employment decisions and which visits minimal intrusion on the legitimate expectations of other employees. Given this fact, as well as the agency's express commitment to attain a balanced workforce, there is ample assurance that the agency does not seek to use its plan to maintain a permanent racial and sexual balance. Well, then define for me what you mean by balanced workforce if there's not something to maintain. What the heck am I reading? Okay, if he hasn't already, and if somebody who knows him or has contact with him could, I would love for Rekieta Law. If I don't know if I never know if I'm pronouncing that correctly. Is it Rekieta? I would love for him to take a look at this, if he hasn't already at some point, and explain to me or explain to the public how this makes any sense, or I guess more on point. Now that the defense of affirmative action in colleges has been shot down, and most of these same arguments that were supporting affirmative action in colleges have been found to be unconstitutional, how quickly can and should these two precedents be shot down as of the decision against affirmative action in colleges? Because what is the point of Title VII? Thank you again, big time. The egalitarianism you champion is used against us, Scribe. No, it's perverted, twisted around, and contradicted, and then packaged as something benevolent. That's the problem. That's the problem. This does not assess people on the basis of who they are. It allows for companies to assess someone on the basis of what they are. In defiance of black letter law. This is such an end run around Title VII. It's such a ridiculous justification. I'm amazed it stood the test of time. But then I guess affirmative action in colleges stood the test of time until this year. So there you go. But again, the thing that boggles me the most is I've never heard of these decisions before as a legal justification and cover for DEI practices. I never have. And I you know, you guys know, those of you that watch my channel, it's not like I haven't looked at numerous examples of DEI arguments, articles, panel discussions, and so on. But here you go. All right. Well, let me see now if I can find the dissents. I should have gotten those the first time around, but I didn't. So let me try to find those real quick. And while I'm doing that, please in the chat, tell me what you think, because I'm baffled. Let's see. Let me find, if I can find the dissent. Oh man, it's all the way down at the bottom, isn't it? Of course it is. Oh man, where do I get to the dissent? Or is this all the dissent? I don't know. How do I tell where the dissent is? Oh my gosh, let me see if I can find it with... it says opinions and dissents. Okay, give me the dissent. Where is the dissent? Okay. Filed dissenting opinion. Yes. Okay, the opinion of the court. Yes. Okay. Okay. Justice Scalia's dissent. Okay, I guess that's about as close as I'm going to get. So let me switch my screen real quick, guys. Apologies. Let me get to the appropriate screen here. Oh, which one is it? There it is. Okay. Is that clear enough? Let me zoom in on that a little bit. Apologies. Okay, we'll get at least one dissent on the transportation agency thing here. Or maybe not if I zoomed in too much. Okay. And it took me away from it again, didn't it? Dang it. Sorry, guys. Sorry about that. Okay, here we go. Justice Scalia's dissent. Let's keep it there. But before I get to that, thank you again, big time. Read the book, Pathological Altruism, Scribe. I think that was a TEDx I watched one time. I think I've seen that. Is that like radical kindness or something? I suppose so. All right, let's see. Justice Scalia's dissent maintains that the obligations of a public employer under Title VII must be identical to its obligations under the Constitution, and that a public employer's adoption of an affirmative action plan, therefore, should be governed by Weigand. I don't know what Weigand is. This rests on the following logic. Title VI embodies the same constraints as the Constitution. Title VI and Title VII have the same prohibitory scope. Therefore, Title VII and the Constitution are coterminous for purposes of this case. The flaw is with the second step of the analysis, for it advances a proposition that we explicitly considered and rejected in Weber. As we noted in that case, Title VI was an exercise of federal power, quote, over a matter in which the federal government was already directly involved, unquote, since Congress was, quote, legislating to assure federal funds would not be used in an improper manner. Title VII, by contrast, was enacted pursuant to the commerce power to regulate purely private decision-making and was not intended to incorporate and particularize the commands of the Fifth and 14th Amendments. Title VII and Title VI, therefore, cannot be read in pari materia, unquote. That's legalese that I don't understand. This point is underscored by Congress's concern that the receipt of any form of financial assistance might render an employer subject to the commands of Title VI rather than Title VII. As a result, Congress added 604 to Title VI, which provides, quote, nothing contained in this subchapter shall be construed to authorize action under the subchapter by any department or agency with respect to any employment practice of any employer, employment agency, or labor organization, except where a primary objective of the federal financial assistance is to provide employment, unquote. The sponsor of this section, Senator Cooper, stated that it was designed to clarify that, quote, it was not intended that Title VI would impinge on Title VII, unquote. While public employers were not added to the definition of employer in Title VII until 1972, there is no evidence that this mere addition to the definitional section of the statute was intended to transform the substantive standard governing employer conduct. Indeed, quote, Congress expressly indicated the intent that the same Title VII principles be applied to governmental and private employers alike, unquote, Dothert v. Rawlinson. The fact that a public employer must also satisfy the Constitution does not negate the fact that the statutory prohibition with which that employer must contend was not intended to extend as far as that of the Constitution. Justice Scalia's dissent maintains that Weber's conclusion that Title VII does not prohibit voluntary affirmative action programs, quote, rewrote the statute it purported to construe, unquote. Yeah, no kidding. Weber's decisive rejection of the argument that the, quote, plain language, unquote, of the statute prohibits affirmative action rested on one, legislative history indicating Congress's clear intention that employers play a major role in eliminating the vestiges of discrimination. How do you eliminate the vestiges, Jesus, of discrimination if you're just going to allow discrimination despite Title VII? Again, there's good discrimination and there's bad discrimination. Regardless of what Title VII says in its plain language, just ignore that. It's fine. As long as you're doing it for the right purposes. 2, the language and legislative history of 703 of the statute, which reflect a strong desire to preserve managerial prerogatives so that it might be utilized for this purpose. If the court has misperceived the political will, it has the assurance that because the question is statutory, Congress may set a different course if it so chooses. Congress has not amended the statute to reject our construction, nor have any such amendments even been proposed, and we therefore may assume that our interpretation was correct. Scalia's dissent faults the facts that we take note of the absence of congressional efforts to amend the statute to nullify Weber. It suggests that congressional inaction cannot be regarded as acquiescence under all circumstances, but then draws from that unexceptional point the conclusion that any reliance on congressional failure to act is necessarily a canard. The fact that inaction may not always provide crystalline revelation, however, should not obscure the fact that it may be probative to varying degrees. Weber, for instance, was a widely publicized decision that addressed a prominent issue of the public debate. Legislative inattention thus is not a plausible explanation for congressional inaction. Furthermore, Congress not only passed no contrary legislation in the wake of Weber, but not one legislator even proposed a bill to do so. The barriers of the legislative process therefore also seem a poor explanation for failure to act. By contrast, when Congress has been displeased with our interpretation of Title VII, it has not hesitated to amend the statute to tell us so. For instance, when Congress passed the Pregnancy Discrimination Act of 1978, quote, it unambiguously expressed its disapproval of both the holding and the reasoning of the court in General Electric Company v. Gilbert. Surely, it is appropriate to find some probative value in such radically different congressional reactions to this court's interpretations of the same statute. As one scholar put it, quote, when a court says to a legislator, when a court says to a legislature, quote, you or your predecessor meant X, it almost invites the legislature to answer, we did not, unquote. Okay. This is getting into deep legalese and everything else. Short version is the majority opinions in both these two cases effectively nullify Title VII so long as you can articulate a motivation that is benevolent based on historical patterns and the demographic split of the surrounding environment to your workforce. Which is, I have to say, exactly the arguments made by DEI oftentimes. And so, unless I'm missing something, it would appear that despite never having been cited to me before in any other example, these two cases do trump Title VII, save for the fact that nearly all the justifications for these two decisions were the same justifications used in defense of affirmative action in schools. And while that case might have only affected Title VI, the parallels to these two cases are undeniable. And so now my question is, what's the point of Title VII? And how quickly can we get rid of these precedents in allowing discrimination to take place in the workforce unbidden? And also, like I say, the Wall Street Journal, Bloomberg, neither of those two publications in talking about the implications of the affirmative action decision on DEI programs ever brought up these cases. So if companies never had anything to worry about in their DEI practices because of these two legal precedents, why have I never heard of them until now? And again, like I say, I'm not a constitutional scholar. I'm not a legal expert. If this has been floating out, obviously this has been out there this entire time. I'm just baffled as to why it was never said explicitly in anything I've ever watched or read that we can do this because of these two decisions. So, all right, well, that is the show. That was educational for me. So, and by the way, if anybody in the chat or anybody in the future knows of anything that either discounted these decisions or overwrote these decisions, or if there's been some action taken in the meantime to try to overturn these decisions, I haven't looked that part up. I'll look that up at another point. But I just wanted to know, based on our two legal experts from the earlier article on the 4th of July, is this true? Are they right? But of course, the curious thing as well in that Catalyst article, if you go back and read it, is the lengths to which those two legal experts advise companies to start thinking about maybe revising some of your policies and language and things, et cetera, and so forth, even though there's apparently a solid affirmative action defense in law. Because I think the writing might be on the wall if all of these same justifications that were used to try to argue for affirmative action in colleges just got shot down. It's conceivably not going to be that difficult a pathway for these arguments for affirmative action in businesses to be shot down. But in the meantime, I'll go to the chat real quick, see what you guys have to say. Q continuum. In short, Amendment 14 was not considered when Title VI was written, which legalizes discrimination based upon categories. In short, maybe I need some more context for that, because I am indeed not a constitutional expert or legal lawyer. Let's see. Who else? Matt, damn good show. Well, thank you, Matt. I appreciate it. Again, I'm disappointed by this information because I was under the impression that we were at a point in our country where if you wanted a job, it was illegal for the company to set you aside because of what you are. You know, and I was boggled all this time that DEI was able to operate seemingly in contradiction to established law. But no, I was the one who was ignorant this whole time. There is established precedent that allows you to do this as long as your intentions are good and as long as you say your goals are not quotas. As long as I don't say my goal is a quota, then I'm fine. Obviously, I've assured the court that my goal is not a quota, so it's okay. And as long as my affirmative action program has the intention of trying to right the wrongs of the past, which obviously Title VII was created to do, even though what I'm doing contradicts the language of Title VII, it's still okay. This is insane. Ostsan, I don't think either decision was overturned, but the Harvard and UNC cases might be good basis to overturn them. I hope so. I really do hope so. Let's see. Anything else? Scanner Daffley, if I can pull this up. Hello, StreamYard. There we go. The reason these cases are not mentioned is probably to protect them. Maybe. Maybe it's just seen as tenuous and as contradictory as I just experienced by reading them. Because it seems awfully tenuous. And I make the same argument for these as I did for affirmative action. If Title VII or Title VI or the intent of the Civil Rights Act was not to eliminate discrimination in hiring, as one example, then what was it meant to do? Why even have Title VII when these precedents allow you to circumvent it? Title VII didn't say you can discriminate against these type of people without consequence. It said, thou shalt not discriminate on the basis of race, gender, etc. But now they're conjuring up these exceptions where it's okay, as long as your percentages meet up with the surrounding population. Oh, but we can't do it. We're not doing it specifically on numbers, but we're trying to strike a balance, not to maintain a balance, obviously. These programs are temporary, but the balance that we create, I mean, if it gets out of balance, then we can work to maintain it again, as long as we're not doing so on a statistical basis or numerical basis. But how do you determine what a balance is? Again, I am a layman. I'm just your lowly English major. I've got your rubber stamp, I can get a college degree. And I read through both of those decisions, and I read nothing but just absolute mental gymnastics around established federal law, not a precedent. You know, not settled law like they call precedents in some instances. No, Title VII. It makes it plain. And the other thing that I find just hilarious is that the web page I got the summary of Title VII from, it said explicitly what we enforce, or the laws we enforce from the Justice Department. I'm like, okay, then how the heck does this make any sense? Or what is the point of Title VII if it doesn't matter with these two decisions by the court? Anyway, I could repeat myself, but I'd be just doing it again. So with that, everybody, I'm going to call it here. This is my educational, informative for myself and for you about a revelation of legal justification that I didn't know existed until this week, and now I know more about it than I did before, and conceivably, so do you. So let me know in the comments what you thought about this. And especially if there's anybody in the chat or anybody that listens to this later that is much more informed on the law than I am, or has a different insight into this than I do, what's the likelihood that this gets shot down or this gets challenged now with the Supreme Court's decision on affirmative action? But yeah, let me know what you think in the comments. Leave a like if you would on the way out, or a dislike. Either way, I appreciate your engagement. A programming note. As an experiment, tonight, Sunday night, at 5 p.m. Pacific time, 8 p.m. Eastern time, I'm going to do something decidedly different than I've ever done on my channel before, because I was talking with a friend of mine last night. We decided to come up with a little goof. Might turn into a thing. We'll see. For reasons that I'll explain tonight, a good friend of mine and I both decided that it might be interesting to read the book, The Interview with the Vampire, and then do a book review on it as we proceed through the chapters. I know it's got nothing to do with nothing that I've ever done before, and it was just on a lark, but just for fun, she and I have each read chapter 1 of Interview with the Vampire, and we're going to talk about it tonight briefly in a little stream at 5 p.m. Pacific, 8 p.m. Eastern. And the plan is thereafter, each week, maybe on a Saturday, we'll review the next 5 chapters of the book and proceed through that. And I don't know if we'll do the whole series of the Vampire Chronicles of Anne Rice, but who knows? Maybe we will. But if you're interested in that at all, that'll be happening tonight. If you'd like to read along with us for the sake of conversation, by all means. But yeah, that'll be tonight. So look out for that. I'll post that soon. In the meantime, everybody, thank you guys so much for joining me. Moderators, thank you for keeping an eye on things, even though everyone here is so well behaved. You have very little to do. Everybody who donated, either to myself or to the fundraisers pinned to the top of the chat box, thank you guys so much for your generosity. Everyone, hope you learned something. Hope you have a good rest of your Sunday. I hope the week ahead is stress-free as possible. I hope you're all safe and well. If you are not well, please get well soon, and I'll see you on the next one. Take care. Bye-bye.